Don't lose your next real estate commercial deal because of a lack of clarity and confusion at the beginning of the transaction. You do not want to waste thousands of dollars in legal fees, your own time, or lose a good investment opportunity because you didn't have a strong roadmap to go from the beginning until the end of the transaction. That roadmap is called the letter of intent. My name is Earl White. I run a real estate law firm in New Jersey, and we regularly work on commercial purchase and sale transactions. And those deals, when done right, begin with the quote unquote letter of intent. This video is going to discuss what a letter of intent is, why it's very important, how it is prepared and executed, what are the key terms in the letter of intent that should be covered, and once this letter of intent is agreed to and signed, what follows after that. So why is the letter of intent important? The letter of intent is of critical importance for a commercial real estate deal because it's going to lay out the framework and set everybody's expectations on how the process is supposed to go. The LOI is going to lay out purchase price, due diligence, financing, tenancies, title conditions. The process for how it's going to go for all the parties is going to be set forth at the beginning in the letter of intent. And it's important for buyers and sellers to have it set forth so they do not waste their own personal time, and they also do not waste any legal fees, their attorney's time, or even the real estate agents that are working on the deal. Lack of letter of intent could mean confusion and lots of wasted time and opportunities for everybody. The letter of intent being properly drafted and agreed to is also a sign of seriousness. So if you're the seller and a buyer shoots you a text message or a quick email, believe it or not, I see these often, in informal communication, that doesn't scream that the buyer's experienced or well put together or is going to make the process proceed quickly. Vice versa, if you're the buyer and you have a lot of money sitting on the sidelines and you want to invest in a piece of real estate, but you get the feeling the seller is going to make the process extremely difficult, then you're either going to want to make sure you have a really good deal or pass on it and get something where you think you're dealing with a serious seller. Now, initial negotiations for the commercial real estate deal will either begin via email, via phone call, some type of informal correspondence, because it needs to be determined what will go in a formal letter of intent. Once the parties have agreed on price, closing date, financing, now it's time to put together the letter of intent. The process for putting it together is going to depend whether or not it's a direct sale between the buyer or seller, or if there are real estate agents involved. If there are a real estate agent involved and the property is listed, then most likely one of the realtors will be preparing the letter of intent. That can have some benefits to keep it less emotional. The buyer and seller going back and forth is not always a recipe for success when things cannot be put in context for them by a real estate professional. But not always. Sometimes they do proceed for sale by owner, direct sales, and that can work too. But if most sales, the realtors are going to be preparing it. The realtors will prepare it. They will circulate it either for written signatures or e-signatures among the parties. Once it's signed, then the realtors will typically gather the contact information for the buyer's attorney, the seller's attorney, send a deal kickoff email introducing all the parties, and then the attorneys can take over preparing the full formal purchase and sale agreement and any additional agreements that are needed as part of the real estate deal. The process is a little bit different with a for sale by owner. They may be a little bit more informal in the beginning, and the parties might just tell the attorneys what they're thinking. And in that case, the attorneys will try to put down a framework, at least in an email or some type of document, to get everyone on the same page before everyone starts spending a lot of time putting together the purchase and sale agreement, when there might be something nuanced in the beginning that could be resolved ahead of time. Now, what does a letter of intent need to cover? So I have here a template with a list of terms that we usually cover in our letter of intent. So first, obviously, we're going to cover the purchase price, the amount the buyer is going to pay to the seller at the closing. So that's obvious. Next important term is the earnest deposit, what we sometimes call just a deposit or the additional deposit. This is the money that the buyer is putting down in the beginning of the transaction that's going to be contributed towards the down payment and closing cost. Typically, that money that's put down is going to be either held in escrow by one of the buyer's attorney, seller's attorney, or the title company that's working on the transaction. This is called the quote unquote sometimes good faith deposit because it's demonstrating that the buyer is serious. The higher the amount of the escrow, the more serious the seller will take the offer. However, buyer doesn't want to go too high on this. So it is something to hammer out in advance. In our market, in commercial real estate deal, You might see something around 10% down, maybe half of the down payment, something akin to that for what you'll see in a letter of intent or in a contract of sale for the earnest deposit. Of course, due diligence, this is a major concern, and something that sometimes will get renegotiated once we're getting past the letter of intent phase, but it's good to lay out the framework. Typically for due diligence, it can vary anywhere between 10 to 14 days for a simple commercial deal, or maybe as long as 30 days for a bigger commercial deal that has more moving pieces. What might happen during due diligence: environmental inspections, general inspections, sweeps for underground oil tank, pretty much anything that the buyer may want to do during this time when they're investigating the property. Besides just the physical inspections, at least a good buyer's attorney will conduct an Open Public Records Act request to see if there's any violations on the property, any open permits, any underground oil tank records, any environmental issues or lawsuits that have been part of the city record. So due diligence, you'll see between anywhere 14 to 30 days. Sometimes that will also bake in other considerations, such as financing. So we also have financing contingency, and that should be covered in the letter of intent. That normally will include the type of mortgage, if there is a mortgage. So there could be a commercial loan, it could be seller financing, or it could be cash. So one of those three options should be laid out in the letter of intent. If it is going to be mortgage and then seller financing, then it should be specified the time period for the loan to get approved, and also the type and the amount of the mortgage that the buyer is going to be looking to obtain, and in conjunction, how much they're looking to put down on the purchase price. So as a seller, you obviously would like more down when you're evaluating the offer. So this is something to be negotiated and discussed as part of coming into the purchase and sale agreement. So definitely letter of intent, you're going to want to lay out the financing type. Now, in terms of having a formal financing contingency, that is pretty much always for residential deals, but in commercial deals, sometimes you'll get a pure financing contingency. Other times, if you have a 30-day due diligence period, then you just have to take care of your financing concerns, your appraisals, and all your inspections at the same time. So if you do have a problem there, then you address it during your 30-day due diligence, as opposed to having a separate financing contingency. Okay, so exclusivity clause. One thing with these drafting the purchase and sales agreements and letters of intent, the parties may not want to put, particularly the buyer may not want to put a period of time into the transaction if the seller is just going to switch to a different offer. So you could propose to put into the letter of intent that the seller will exclusively negotiate with the buyer for 14 days or 21 days, something like that. So the parties are aware they're not wasting their time working on finalizing a purchase and sale agreement. So that's another term that you may want to put into your letter of intent. Target closing date. Of course, the parties typically want to close as soon as possible on commercial real estate deals. The real estate closing date for a commercial real estate deal, anywhere between, if it's cash, 30 days. If it's financing, it could be up to 60, 90 days, just depending on all the mechanics involved. Perhaps it could be longer if there's zoning approvals involved. And of course, the closing date is going to be contingent upon conditions being met, such as the seller being able to deliver clear title. There may be municipal inspections, certificates of occupancy, and other government certificates that need to be obtained, which can delay the closing date. So closing date is flexible. In New Jersey, the closing dates are not what you call time is of the essence. The courts have ruled that the closing date is not firm. So if we get to the closing date and one side has not done what they're supposed to do, the other side can serve them a 10-day time, quote unquote, time is of the essence letter, after which they would be in breach of contract by failing to close. In practice, we usually don't jump to serving time is of the essence letters because the parties want to work amenably together to get to the finish line, which is everyone's goal, not to have a lawsuit. But if that were to happen, the parties were to get frustrated. That's the mechanism, time is of the essence letter, if we pass that closing date. Part of the letter of intent, we also have property description and the condition of the property. So if the seller has a survey, that can be incorporated into the letter of intent, or at least a prior deed legal description, you can work that into the letter of intent if you want to be very thorough. Also, anything to do with the property condition, if there are problems with the property that you want to be as is and the buyer not to have inspection contingency rights to it, and certainly you could disclose them in the letter of intent. Confidentiality. Confidentiality is an important term to have in the letter of intent because you may not want the deal marketed. So For example, if you have a buyer and you're sharing sensitive materials, you may want it formally written down in writing that they are not going to circulate any additional information that the seller is sharing with you as part of executing the contract, such as leases, rent rolls, maybe back title surveys, any blueprints, plans they may have, permits. They don't want that to be public knowledge, so confidentiality provision in the letter of intent is a good idea. Allocation of closing costs. So closing cost breakdown is normally standard, but in the case of if you have a lot of tenancies here, then there may be questions if we close on the 15th of the month and all rents were due in the beginning, whether or not or how rent will be distributed at the closing. A couple options are, if rent's not due, the seller could take a credit for their days of ownership and the buyer could collect the rent afterwards and keep the full rent. You could have an escrow established at closing where rent's not paid, so the seller will then put in escrow, will put money in escrow, so when the rent is paid, then the escrow can be distributed to the respective parties. You could also have the seller give a credit to the buyer if the payment's already on the way to the seller. Rather than trying to cancel it, the seller can just collect the last rent period and then the buyer can take a credit at the closing. So that's the type of issue. If you want to hammer it out in the beginning of the sale and present it to the attorneys, that could help a bit. And those are the main terms that you want to cover in a letter of intent. What happens after the letter of intent is signed? Once the letter of intent is signed, the next step in the process is that either the listing agent or the realtor for the buyer will collect the information for the respective attorneys. So the buyer's attorney and the seller's attorney. They'll then typically send a deal kickoff email to the attorneys, introducing the parties, providing the contact information of the attorneys and any legal assistance to include in the process, the letter of intent itself, and any other addendums that need to be executed or signed. There may be a preliminary phone call between the attorneys to discuss things at a high level, particularly if anything was missing from the letter of intent. But hopefully, if they watch this video and went into good detail, there won't be too much that is missing from the letter of intent. Once we've confirmed the contents of the letter of intent, then one of the attorneys will begin drafting the contract of sale. Typically, that will be the seller's attorney in most cases, but that is not how it has to go. It can happen on either side. The contract of sale typically is going to vary depending on how many units the property has, the purchase price. If it's a small mixed-use purchase for $500K cash, you're not going to have a 40-page purchase and sale agreement. However, if you have a purchase price for $5 to $10 million plus, you're talking 8 to 50 units, whatever those numbers are going to be. At that point, it may slow down and get a little bit more sophisticated because we're dealing with more leases, tenant estoppels, perhaps more financing elements going on if it's going to be a loan of that magnitude. So that's something that the attorneys will discuss at the beginning of the transaction. Once everyone's on the same page, now it's time to put quote unquote pen to paper. And that's by that, I mean the attorneys putting together the contract of sale and negotiating it. Like I said, if the letter of intent was done well, it'd probably be pretty straightforward. But now we'll get into the nitty gritty of what needs to go into the contract of sale. Things that the attorneys may cover that the letter of intent probably didn't cover is tenant estoppels, such as getting commercial tenants to sign statements confirming that they're leases. There'll be more thought out or more detailed provisions relating to the conveyance of clear title from the seller to the buyer. So to make sure any type of liens will be resolved, and if there's some liens that are staying with the property, what is the context of those liens so the parties are all on the same page. Attorneys may negotiate any escrow agreements to resolve environmental issues, things that probably are better worked out through the attorneys than the realtors in putting the letter of intent. Though again, that would even be good to put in the letter of intent that the parties are open to the same solution on resolving an environmental or extensive property damage issue. So those type of issues, attorneys will come on, we'll put together the contract of sale, then we'll circulate it to our clients for their feedback concurrently while negotiating it. Once the parties are in agreement on the contract of sale, we'll have it signed and we'll begin the sale process. The key takeaway regarding letters of intent in commercial real estate transactions is that they set up the transaction for the highest likelihood of success when they are well thought out and detailed. They will save you time, save you money on legal fees, reduce your stress, and increase the chances of the parties getting the successful outcome, which is the seller selling for good net sale proceeds and the buyer getting their next real estate investment deal on the table and to the finish line. If you need help with a real estate transaction in New Jersey, give us a call, 201-389-8275 for me directly. Feel free to call the company line, www.earlwhite.law.